Yeah, I know out there, so.
Will I do intro? Oh.
Yes. That's why you're here, right?
This is my really good friend, Danny. I do you want me to introduce it? No, you can tell him. So, well, thanks for coming out on a Friday morning. This is Daniel Dardani from the MIT licensing office. Danny and I crossed paths when I was at MIT, and he quickly became my expert go-to for software IP, and still, whenever I have questions, I'm always emailing Danny. Can you help me with this stuff? So, but I'll let him give a little more descriptive about his work and where he is at MIT. Something I haven't been there.
Thanks, Carrie. And thank you and good morning for spending some time. My name is Dan Dardani, and I do work at the MIT Technology Licensing Office. I'm a software licensing officer there, which means I primarily handle algorithms, computer sciences, anything sort of reduced to a bit or a byte is probably going to find up in my portfolio. I work closely with faculty all over the institute because, as you know, software sort of touches a little bit of everything, from bioinformatics to encryption to traffic systems and beyond. So I'm here today to talk a little bit about intellectual property in general. For those of you who may not be familiar with intellectual property or might be doing work and figure out, not sure when to go talk to Corinne and Carrie and tell them about all the cool things you're doing, when you might have something that might cross over into patentable subject matter, and when you're just doing code that might be licensable. So I'll talk a little bit about the basics of IP. If that's boring or if that's too elementary for you and you want to skip ahead to specific issues you guys are seeing in your own group or your own lab, please feel free to interrupt. It's an informal presentation, and my time is really here for you, so whatever you guys want to do with it. I've given this talk twice now already since I've been here yesterday, so I'm tired of hearing myself, but so by all means, please ask questions or interrupt me, because we can go down tangents, and I'd probably appreciate it. So I'm just going to jump right into the few different types of IP that you may or may not know about. The first is patents. Patents protect inventions, as you all know. We tend to think of patents whenever we think of intellectual property because they protect sort of all of the neat things that are going to be changing the world for tomorrow. It's sometimes helpful to remind ourselves that patents actually go back to the Constitution, our founding fathers. It was the first clause of the Constitution that set up a patent and copyright system. So, even though we think of it as an utterly modern endeavor, it actually has quite a long and standing tradition in our history. So let's talk a little bit about what is a patent and why you might want to get a patent. Okay, so the law is that whoever invents or discovers a new useful process, machine, manufacture, composition of matter, or an improvement can obtain a patent. Now, we don't tend to think of the world in terms of processes, machines, manufacturers, and compositions of matter. But for the most part, we'll come back to and analyze those. They really encompass almost anything you can think of. Composition of matter can mean composition of matter in a biological or chemical sense. A machine is not just literally a machine. It could be anything that sort of acts on and implements a process, a manufacturer, and of course the ability to always constantly improve or build a better mousetrap is included in the patent law. So whenever you do something, and we'll sort of discuss what the three traditional requirements of patent are, whenever you sort of act on something and add some ingenuity to it, somehow change it for the better, you might be inserting some patentability into whatever it is you're doing. Well, that's the thing I want you guys to think about. Now, if you get a patent, you might think, okay, great, we have a patent, now what? So the rights in a patent are simply the rights to prohibit others from making, using, or selling your invention or importing your invention in the area where you might have a patent. And that might be important because if the patent law didn't protect against importation, then everyone would just get around a patent by making sure they made the product outside of the area and then sneak it back in to sell. So if you have a patent in the U.S., you can basically stop someone from making that product in the U.S. without your permission and selling that product in the U.S. without your permission. So even if someone goes offshore to make your idea, they still would be stopped if they tried to then come back into the United States to sell. What you could not do is stop them from making and selling their product sort of in another country. That you'd actually have to go into that other country and work with that other country's patent office to file a patent there in order to stop that. Now, the right in the patent is not necessarily a right for you to make your own product. Notice it's a negative right. It's a right to stop others from making your product. And that's important because if you had a right to make your patent unilaterally, you would preempt other people's patents who might sort of dominate or sort of trade very closely to your patent. So no one would ever license anything. If they ever had anything they wanted to do to beat their competition, they would just patent their own version of it and trump the other patent. And that would sort of lead to a very messy system. So the patent law is sort of built up as a negative right so that it turns out you actually might need to license another patent in order to practice your own invention. Because if you have a patent and your patent is dominated by another patent, their dominating patent can actually prevent you from making your own invention. And again, you don't have a right to make your invention. You just have a right to stop others from making your specific claim. Is that clear? Kind of an interesting nuance of the law. How long does a patent last? The current law is 20 years from your date of filing. So you would file a patent, and there's a little bit of I won't get into the legal details of filing a patent for now, but you know that filing process can take X number of years. Before it's even reviewed by the patent office, you could be sitting on a patent application 3-4 years. So if it and when it's granted, your actual patent term is going to be 20 years from the date you filed it, not necessarily from the date it's been issued. Just remember that. What are the requirements if you were to try and think about a patent? There are 3 traditional requirements: new, not obvious, and useful. Those are the ones that everyone seems to remember. Those are the ones you might take away from this talk. They are the traditional requirements for patentability. There actually are 2 more. Subject matter has to be patentable, and you have to have essentially described your invention, enabled your invention in writing so that one of ordinary skill of your art can understand it. Now, novelty has a statutory definition. To be new means that it cannot have been known in the general public, in literature, in other patents before you submit your idea. So one of the first things you might do to say, should I file my invention with my licensing office, is let's do a search. Let's do what we call a prior art search. Let's see what's come before us. And that's going to give you a quick snapshot of whether or not your idea is truly new or not. Now, it turns out that most ideas have been probably thought of or filed on in some form or another. But there's always the ability to get some sort of narrow aspect, some sort of claim that hasn't been exactly expressed before. And that's usually what becomes the sort of germ, the kernel that might be your patent. So just because you find some prior art out there that might be related, it's not a deal breaker. It's just helpful to know sort of what the lay of the land is so that you can sort of figure out where exactly your patent might lie in terms of what you want to claim. So if it's already out there in the world, it's not new. If you yourself have told someone about your idea, public disclosure, that's going to start a clock about how long you can take to file a patent. So if you tell someone sort of outside the scope of your lab or your university, like a company, or if you give a presentation and you provide slides, if you publish, if you submit a paper, all of those things are public disclosure. They're going to start a 1-year clock. And if you don't file a patent within that 1 year, it's pretty much over. You're going to sort of have ceded your idea to the public domain, and you won't be able to then file your patent. So if you're thinking about a patent or you're not quite sure, my advice is go talk to the licensing office because they can act on it, they can assess it, they can review it in anticipation of any public disclosure. Maybe file a quick provisional or something like that to protect it, and then you can go and disclose and not have any concern. Usefulness is a very, very low threshold. It almost doesn't even come into play anymore, so I won't spend time on that. The not obvious rejection, this is a big one, and this is why patents cost on order of $15,000 to $30,000 in the United States. And it's because the examiners in D.C., their job is to sort of protect the general public, the common good. So when you file for a patent, you're obviously going to say that you're great and you've invented everything under the sun and you want as broad a claim as possible on it. But it's their job to sort of be the polar opposite and say, well, what you've done has been anticipated before by lots of other things that have come before you, pardon your brilliance. And so they're going to reject most of your claims and cite what they feel are other patents or other documents that anticipate your claims. In other words, rendering your patent obvious. And so it's your, or more specifically, your attorney's job to articulate arguments to overcome those obvious rejections. And that back and forth, it's like a 3-round boxing match. They call those office actions. That is really what eats up a lot of the patent attorney's time. Patent attorneys command a pretty good salary, and so that's what usually winds up adding to or contributing to the expense of the patent. But it's an important step because this is sort of the dance between you as the client and the examiner in DC as to exactly what's going to be the heart of your patent. So it's important to fight for your claims as hard as possible, because if you sort of have your claims whittled down or narrowed down so much, you might get a patent, but it might be so narrow it's not really worth the money at that point. Do you have a question?
Yeah. Can they use non-patented material to make a case that your attempt at a patent is not is obvious, or is?
It's a great question. Yes, they can.
Just public material.
Because part of the novelty definition is not just patent documents, but anything that's known.
That's out there.
Anything that's out there.
Can make it obvious.
Textbook, it could be paper, it could be something that's just sort of in common sense, generally known. It could be a product that's on the market. So it turns out that almost anything that they can find to show that your idea existed before you thought of it can be held against you.
Right.
So, but because you don't have the time to really search everything in the world, usually what you'll do during a prior art search is look at all patent documents and literature searches.
Yeah.
As academics, you probably are fairly up on the literature part because you have to do that before you publish, and you're usually knowing what the state of the art is in your area because, again, it's important for when you submit to journals, but you might not know what's out there in the patent world. So that's where a good prior art search with your licensing office might really add some value. So the two other requirements, which don't get as much popularity, but they are important nonetheless, is you have to be what's called in the subject matter of a patent. And we'll talk about this because it does affect software and things like that somewhat. But if you're filing a patent on something that inherently isn't subject matter, you're going to get a rejection of your patent. And of course, you have to then, again, describe your invention. You can't just file a patent without providing the details that actually sort of show why you should be granted a patent. They call this a few things: reduction to practice, constructive reduction to practice, best mode, or written enablement. The idea is simply that really the patent law in its original concept was a contract between the government and its citizens. You tell us all these great things that you've invented personally, which you don't necessarily, we can't force you to do it, but we're going to incentivize you to give us this information willingly, voluntarily, and we'll give you 20-year monopoly to sort of exploit it and benefit from it. And so we're benefited from it, meaning we, the country, because you're giving us private information that you otherwise might keep to yourself, and it's going to go into a corpus of information, the common good. You can look up any patent that's ever been filed since the patents have been around, and people can read them in the library and turn them upside down and figure out whether or not they can improve upon them and increase sort of, society, push technology along. So that's the quid pro quo. We want you to tell us exactly how it works, exactly what you know about your invention, as detailed as possible. And in exchange, we're going to let you and only you, hopefully, derive benefit from it for a limited time. So it's important to make sure that the patent is described or reduced to practice so that, again, one of ordinary skill in your art can understand it. Not necessarily the average person on the street can understand it, a person subject to the same expertise that you have. And this is also how we protect ourselves from filing silly patents on perpetual motion machines and anti-gravity boots and things that don't really exist or violate laws of physics, because they'll never pass the written mode or the enablement barrier. Okay, so let's flash forward to copyright. So patents protect inventions, technologies, things of that sort. But there's another kind of IP that's just as important and just as valuable, doesn't get quite as much press. But, it's the copyright. The copyrights are probably a little bit more close at hand to us because we interact with them, movies and books and songs, things like that. That's really the domain of the copyright. So let's just see what it is. Copyright subsists, that is to say exists, in any original work of authorship that gets fixed in a tangible medium of expression. That's the statute definition. When you have those elements, you have a copyright. And we're going to talk a little bit about what it means to be original, what a work of authorship is, and when something is fixed in a tangible medium. But just know that if you have those three elements, you automatically have a copyright. That's just the rule. Now, if you have a copyright, you might say, what do I get out of it? What are my rights? The rights to a copyright holder are the rights to reproduce your copyright. And as you know, you have the right to do whatever you want with whatever it is that work is. You can make a copy of it in any form, literal or non-literal, and no one else can. You can prepare a derivative work. A derivative work is another work that's based on the original. The classic example is a movie that's made from a novel. That movie is its own work of authorship, and it's fixed, so it's copyright, but it's based on the story of the novel. Therefore, it's a derivative of that earlier work. For software, a derivative is going to be when you take code and you enhance it. You add more lines of code to it, you add new modules to it, you might translate a program from one language to another or one operating system to another. When you're doing that, you're essentially preparing a derivative work. You as the copyright holder also get the rights to distribute your work, whether by sale or other, to perform and display your work if the particular piece lends itself to that, like artwork in a museum gallery. So a patent lasts 20 years from the date of filing, but a copyright lasts much longer. A copyright lasts for the lifetime of the author plus an additional 70 years. So a much longer lifespan for copyrights. And there's lots of stories behind that, but it basically had to do with long-standing tradition of extending the copyright, and most recently Disney sort of lobbying Congress to extend an additional 20 years of all copyrights because Mickey Mouse was going to go into the public domain. So you should know a few things about copyright. Copyright exists upon creation or fixation, to be more technical. So if you're taking down notes right now on a pad and paper, you're creating a copyright because it's an original work that's original to you, and you're fixing it in a tangible medium. You don't need a government to grant a copyright to you. You don't need any other formalities. It's just created automatically when you do it. You don't need the C with the circle around it like you sometimes would see. And you don't need to register it formally. You can register it formally. Fill out a form, pay $35, send it to the Library of Congress, which is Copyright Office run out of the Library of Congress. And they'll send you a registration number. They don't review it. There's no sort of back and forth like a patent. It's basically a rubber stamp. Now, you might want to register your copyright if you ever plan to sue someone for copyright infringement. In fact, it's required. But the good news is you could always register your work on the way to court. So there, you don't have to worry about if I didn't register it, when I first created it, have I forfeited my right to sue? No. You can always do it after the fact. There's an advantage for doing it earlier because if you register a work that someone copies, you're entitled to what's called statutory damages, which means you don't have to prove your loss in court. You can just say, I'm entitled to X number of dollars under the law. Here's how many years my copyright has been infringed. Do the multiplication. Here's how much I need. And that's a nice. That's a nice, convenient advantage. And that's why publishers and people who are in the professional business of creating works will always file registration forms. But at MIT, we never file copyright registration for software and things like that because it just doesn't come up that often, and we're not generally in the business of launching lots of lawsuits against folks. So let's talk a little bit about what works qualify for a copyright. These are the 8 ones that are in the law. Literature, you might think everything that's covered in books and in writing. Music, and by music we mean both sort of the composition that the composer would create, as well as the lyrics that go into a song. Dramatic works, anything you would see in the theater and plays, choreographic works, dances, anything that was considered art, whether it be pictorial graphic, photographic, sculpture, paintings, movies, sound recordings in movies and music studios, architectural works, including both the structure of the building in some sense and the blueprints that underline the architecture, and so forth. So some things that are not protected ever, facts. A fact is just a fact. Facts should not be owned by any one person. So the fact that it looks like it's raining or was raining this morning is a fact, and that's not something that could be copyright protected. Ideas in themselves are not protected under copyright. So if you write a book about how you're going to solve the Middle East peace process, that does not give you a copyright over that sort of that peace process solution. Just the thesis, that the words that you've used to describe your thesis are what is copyrighted. So copyright really is protecting the expression, how you express the idea, not the idea itself. Ideas are always free. No one owns ideas. That's an important part of IP, and from its infancy. Thomas Jefferson got really up in arms about whether or not IP should, really be strengthened or loosened, and he was very adamant about saying, ideas, no one can go into your head and take an idea out. So ideas in and of themselves are never protected either by patent or copyright. What we're protecting is our particular way we express that idea, whether in engineering through a patent or through literature or music or writing for copyrights. So ideas are never, ever, ever protected under any form of IP. So it's true for titles and short phrases, things like that. You sometimes hear in the news that someone's trying to copyright a phrase like "you're fired" or something like that. That's not true. They're actually talking about trademarks and things like that. Very different form of protection. Procedures, processes, methods of doing business, those things are not protected under copyright. We learned that a process or a method or a procedure can be protected under patent. So if you want to actually protect a certain step for how to polish a particular material using a particular chemical, that could be something you could take to the patent office and try and protect. But that's not something that copyright's going to protect. So there was a case where someone wrote in the 1800s a book about how to sort of manage the account of a business using a series of ledger tables, sort of like an early spreadsheet. And the book was popular and people did use the spreadsheet. Someone went into business trying to create the spreadsheet and sell that to companies, and the author of the book sued the company that was making this sort of business out of it. Said, that's my idea. You took that out of my book. I'm the one that should be benefiting from this business. And he lost, and appropriately so, because all he had was he had a copyright in the book, and the book did not bestow any rights to the actual ledger system or the technology itself. If you write a book about MRI technology and the latest advances, it doesn't mean you automatically get rights to the MRI breakthroughs, for example. So principles, discoveries, any work of the United States government is not copyright protected. That's just by law. So if you are acting as an employee of the United States government, any white papers you create or any documents like that are not going to be held as copyright protected. They're in public domain.
You have to be acting as an employee.
You have to be acting.
If
it's funded by the government, you still have a right to take title of it as a contractor. It's only if you are an actual employee of the United States government. And lots of things that we do at universities are funded by the federal government.
Yeah.
So, and everything is owned by the contractor, whether it be the patent under the By-Dole Act or software under the FAR clauses. The government always gets a non-exclusive royalty-free license to it anyway, so they're happy the fact that they can use it. But it's just a formality that no employee of the government can have a.
Can they use it? Can they give it to someone else?
They can. The rights that they have include the right to give it to a contractor that's doing work on behalf of them.
Okay.
And so if there is someone who's doing a contract work for the government and they ask us as the contractor or the creator of the program to license it to them, we have an obligation to give it to that company under the government contract. But only for that government use and only sort of that limited time that they're working for the government. It's not a license they get in perpetuity to use on other projects. They also can't get it if they're prospecting for a government grant. A contractor might come to you and say, I'm thinking of putting in a proposal for the government, and I'd like to get this software under the free or reduced government rate. No, that doesn't work.
But you can charge them for that, your licensing.
Yes, yes,
So if you have a licensing fee policy for that product.
correct.
Does that apply to state government as well, or are they separate?
It doesn't apply to state under either by dole or the sort of most of the federal funding that universities get. Depending upon how much of a stickler you want to be, we usually extend the same courtesy to state and local government. We don't have to, but for the most part, we wouldn't necessarily try and hold them accountable for that. So this question about copyright of software. So when we write code, obviously the machine language likes to look at zeros and ones. This is like the matrix, but we can't write in zeros and ones very well. So we create source code, which then gets compiled into machine code, which is read. And so the question is whether or not source code is the same as this sort of essay, because this essay certainly is copyrighted. It's literature, and I guess the question is, let's apply our three-step test. Is it an original work of authorship? What do you guys think? Is software original work of authorship? Definitely. Anyone who's written code knows that it's not easy, and no two people will write the same lines of code to do the same thing. Is it fixed in a tangible medium?
Yes.
Yes. There it is right there, printed on paper, or maybe on a screen, just like this. And so fixation, whether in RAM, ROM, or on a hard disk, or thumb drive, or printed on printer paper, all of that counts. So these two are equivalent, and because of that, software is protected under copyright. So let's talk a little bit about open source, which is another area that is increasingly becoming a part of our world. So because software is protected by copyright, the question is it needs to be licensed. And it can be licensed directly under a closed license, like between the university giving it to a government contractor, as we just said, or it can be licensed more broadly. So when you want to provide your software out to the general public, where you don't care who uses it, who works on it. This is where we sort of talk about things being open sourced. Now, there is no one open source license. Some people sort of make that confusion and say, oh, I'd like to keep this as open source. And then when you ask, what do you mean, what license? They go, oh, I don't know. It's just open source. Open source itself refers to a standardized body, opensource.org. They're a branding body. So all they do is they essentially will collect license agreements that people have submitted and then brand them as open source after they've been approved. So when you say you want to open source something, it's probably more accurate to say you want to publicly distribute something broadly to the world. But then the question is, under what type of license would you like to distribute it? And so there's an extra layer that goes underneath that. So within the opensource.org foundation, there are, I don't know, 30 to 40 licenses or so of open source licenses, like flavors of ice cream. And each one has different terms and conditions, and each one is slightly different. And so you have to pick which open source license you want your code to be sort of distributed. Now the benefit of open source is that these licenses are out there and they're known, so people exactly sort of know them. They know exactly what they're getting into. There's no fine print. There's no contract that your lawyer has to send their lawyer to review. Because these things are known commodities out in the world, people understand them, and they have sort of an experience working with them. So everyone knows what they're getting into, and that's why people will continue to use them. There are different types of open source licenses. I could speak to a few just to give you some background. One of the most popular was started by Richard Stallman, who was the creator of the Free Software Foundation at MIT in the 70s. He believed very strongly as an activist that software was heading in the wrong direction in the 70s, and it really needed to be more free and open so that everyone around the world can sort of act as a developer, work together, and collaborate on software. And so his brainchild was to create a license called the GNU GPL, or General Public License. And under that license, he wanted to sort of use the copyright law against itself. This is what the copyleft symbol here means. So what I mean by copyright law against itself was the GNU General Public License is a license. It's not, the Wild West. You can't do whatever you want with it. You still have to abide by the terms of that license. And so it's just like entering into a private license between two companies. But the terms of that license sort of work to undermine what companies do to keep software closed and sort of behind closed doors. The General Public License says that whenever you take code from the General Public License and you make a change, you have an obligation to upload your change in source code back in. So you have to sort of disclose everything you've modified and provide the source of all your changes. And it also says that if you distribute your code back to someone else, all of that code that you've included is going to be under the GNU GPL license as well. So you don't get an ability to sort of change horses in midstream. The license is going to sort of stay GNU GPL throughout its evolution regardless. Everyone coming in downstream has to agree to put their changes back and also put their changes out under the same license. And so it's kind of like a viral license in the sense that this code has the flu, and any code it touches is going to transfer the flu to that code as well and propagate it and so forth. And so it has the chilling effect on companies because a company which is interested in keeping their software closed or proprietary is going to want to stay clear of any GPL code, because you can imagine what would happen if Microsoft sort of accidentally put out a change with GNU GPL. Suddenly they'd have to open source their entire code base. So it has it wasn't necessarily designed to be anti-commercial, but it's had that effect that companies, generally speaking, do not want to use the GPL. They use it in very small pockets internally because the license is only rendered effective when it's distributed. So if they want to play with it sort of in a clean room where it never will see the light of day, they're not beholden to abiding by the license. But if they ever do anything where it gets distributed or sold, then they're in trouble. We have a program at MIT that is a four-year transferring program, FFTW. And the strategy for licensing it is essentially we provide a version to the open source community so that anyone who wants to play with it as an academic or just for non-commercial research purposes can do so. And they like it. And because it is really, really fast, companies also want to use it. And so what happens is companies will sort of play with it, understand how it works, turn it upside down on its head, really get to know it sort of in a closed private environment where they're not going to necessarily infect themselves. And then they come to MIT and say, we'd like a license to FFTW, but we don't want to take the license under your GNU GPL version. We'd like to take a license privately under a closed license that you give us separately. And you're allowed to do that because you can sort of bifurcate the code and have a branch that exists for the public to use and play with, and another branch that's separate that you can license commercially and privately. So we do what's called hybrid licensing, where people who want to use the free version don't even have to contact us. It just exists on its own in the public. And we then get contacted by commercial entities that want to license this closed version and pay a fee for that closed version. And we probably do dozens of licenses a year, and the revenue in upwards of millions of dollars over this code over time. So it is an important way of raising exposure to work you're doing and sort of satisfying certain constituencies like academics that might want to play with your code, but you're not necessarily sacrificing the ability for it to be commercialized and potentially go into other means of productization. Lastly is the Creative Commons, that's the CC. This was Larry Lessig, who's a Harvard law professor. He came up with the idea that he wanted to sort of create an a la carte series of licenses for folks who create works to license their works under certain terms and conditions. But he wanted to do so and expand the scope beyond just software. So Creative Commons is kind of like what this is to software. This will do for all different types of works, not just under software. So an example would be you author a book and you do not care if anyone on any college campus or university anywhere in the world uses your book, copies your book, passes it out to students. You feel that that is something you want to encourage, promote. So you can select a license under the Creative Commons work where you release your novel that says, as long as you're doing something for academic research purposes, non-commercially, you do not need to contact me or my publisher for permission. And that's it. And so what it means is that people in universities will use your work quite liberally without being worried about it infringing it. And anyone else that wants to do anything with your work or your book would have to come back and talk to you and sign a different license agreement. So it provides a nice series of options for you to pick and choose. One way to think of it is traditional copyright is all rights reserved. You're not allowed to do anything unless you talk to me because I'm the copyright holder. Creative Commons is more like some rights reserved. I want you to talk to me in certain situations, things I can give you permission for. Other things I already have blessed, feel free to infringe my copyright without any fear. Okay.
Can I ask one quick question about
Yes.
software? What if it's like a script or something that you build on top of other software? Like, you know, you've got a licensed software like ArcGIS or something, but you build a script that does something within the software that, you know, you've designed, you've written. It can only be used in that software, but it's, you know, its own thing.
So because it's its own thing, it's going to be its own copyright. Now, regardless of whether or not that has any value or merit insofar as it needs to link into the other program, it's sort of it's just an oddity of it, but it in and of itself doesn't affect the fact that what you've created is your own work. I guess if the facts were different and the program would run and then you'd have to sort of create something that was embedded in the program, then you might argue that you're creating a derivative of the original work. But I think in your situation, what you've done is you've created something that is your own copyright, but it just so happens that it's only really valuable if used in conjunction with the other work. And there's nothing wrong with that. You can release that code under any license you'd want, even using sort of an open source license under the intention that it's going to be used in conjunction with that other program. You could approach that other company if you thought that there was, you know, some means that if there was some value in that script of what you've done, that they might want to buy it from you to have the rights for them to sort of use it and incorporate it. You could do that. So you really have lots of different options. But I think to answer your question is that work would be your own copyrighted work. So now we're going to talk a little bit about trademarks. Trademarks come into play because they're another type of intellectual property, and they can be used effectively in terms of branding a company or a business or even a product. And sometimes when there is no ability to patent it, or if the copyright rights are thin, you could really use branding and trademarks effectively to create value in sort of a new business or a venture. So a trademark will include a word, a name, a symbol, a device that's used in commerce to distinguish goods or identify the source of the goods with its users. So patents were technical, copyrights were sort of works of authorship. Trademarks are all about commerce. There's really no lofty public good sort of intentions. It's all about just, we want to make sure that there's no confusion in the marketplace by consumers who are buying products. They want to be able to know that when they buy Coca-Cola, that's what they're going to get because they know every time they drink Coca-Cola, they have a certain experience with Coca-Cola, and that's what they're paying for. And if they didn't want that, they would then buy RC Cola or some other, you know, no-frills cola. But because they like that experience with Coca-Cola, they identify the source of the goods, and they're willing to pay for that particular product. That's what trademark is all about. It's about trying to make sure that the consumers are not confused and that they get essentially what it is that they're paying for by the providers of those goods. So trademarks, as you know, come in all different sort of varieties, visually to otherwise, but they immediately tell you who it is and what you're getting. So the rights in a trademark are essentially just, again, the rights to use it in commerce. If you have that mark, you have the ability to stop anyone else from trying to use that mark or use a confusingly similar mark because they might be trying to ride your coattails and get some of your customers. The duration of a trademark will last indefinitely long. It doesn't technically go abandoned ever unless you let it rot. So if you ignore your trademark or you leave your trademark, it can actually go away. If the business sort of folds over time, the mark can actually sort of slip and then go to actually another company. Happens all the time. So trademarks can be just about anything you can think of. It doesn't have to be a visual logo or a graphic logo or a name. It could be a phrase. Of course, it can be a symbol like the Nike swoosh, but it could also be very abstract things like a color. The example I've been using the last couple of days is Owens Corning's pink house insulation. Just the fact that they paint their insulation pink has distinguished it and identified it with Owens Corning, the Pink Panther logo. So if you were in that business and you decided to use other pink insulation, you would be confusing customers into then thinking it's Owens Corning, and you would probably be sued by Owens Corning. Sounds can be a trademark. Watching TV and you hear NBC, that ding, 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 that makes a certain connotation that is NBC, and you recognize that immediately. The Harley-Davidson company tried to trademark the sound of their Harley-Davidson motorcycle because they thought that nothing sounds like a Harley. There are fragrance companies that have tried to trademark how certain perfumes smell because they feel that they can be distinctive and people who are in the know can associate a particular fragrance with a provider. So anything almost you can think of that can create a relationship in the mind of the consumer to the source of the goods can actually work as a trademark. The question is, how do you get a trademark? Well, you have to apply for a trademark. Like a patent, you actually have to fill out a form and send it into the USPTO, make your case, and if they approve your mark, then they will send you an approval, and then you can put a little R, can't really see it, but there's an R with a circle around it, and that means that your trademark has been registered and can now operate in commerce. If you're not quite ready to register your mark officially, there is a common law designation, little TM after the product name. So for those of you who are thinking about a company or thinking about something that you're doing in the lab you think might have commercial potential, you kind of want to reserve it, you know, you come up with a new traffic algorithm and you think that you want to call it sort of traffic DNA, you know, after traffic DNA and whatever literature you're putting, put a little comma and then a small TM after it. And now you're putting people on notice that you think traffic DNA is your mark for this particular algorithm that you've come up with in your lab. So not all trademarks are approved. They can be rejected, and I won't get too much into this, but essentially things that are deceptive, scandalous, disparaging, they're going to have a harder time getting approved by the PTO. The troubles with the Washington Redskins and their mark, Native Americans are constantly fighting because they feel that that mark is disparaging. So they've had their issues. There's all kinds of rules against not using flags and not using like signatures of presidents and names of presidents, things like that. I won't get too much into that because that's sort of more 201 stuff. But how your product is presented to the world can also identify or distinguish the goods themselves. And therefore, they actually also get protection in the law. This is called trade dress. So it's not just the product or its name. It could actually be how the packaging or how the sort of product looks. So everyone knows what that is. I don't have to tell you. You may remember what that was, and of course everyone knows what that is. All these things constitute trade dress. You cannot put your product into these shapes or deliver your products into these shapes because they have their own form of protection, just like a mark, and you'd be sued for trying to confuse the public. And Apple and Samsung actually had played that out in the courts the last couple of years, in terms of the design and the sort of look and feel of sort of their phones and tablets. For trade dress, we're only protecting ornamental aspects, not functional parts. So, you know, the bottle, the lip of the bottle where the soda actually comes out is not what actually is protected, just sort of the ornamental aspects of the curves. So, okay, trade secrets, the last thing I'll talk about in terms of IP. A trade secret is another type of IP and yet another thing that a company can deploy in strategy of keeping sort of technology that's valuable protected. Trade secrets essentially apply to any information that otherwise is not generally known in the public, therefore it's a secret, and that it conveys a particular advantage or economic competitive advantage to you as the holder of the secret. Now that value can be real or it can be perceived. It's really subjective. But the point is that if you feel that you are in possession of information that provides you a competitive advantage in the marketplace, you have the ability to keep it as a trade secret. The most famous trade secret of all time, Coca-Cola formula, right? So they could have patented that formula because it was a composition of matter and it would have fit all the elements of patentability, new, not useful, new, useful, and not obvious. But what would have happened if they did was everyone would have known the formula after, at that time, would have been 17 years. Because part of the patent is disclosing everything about the patent. And they could not have kept the formula secret and get a patent at the same time. That's the quid pro quo. So what they did instead was forego patent. And of course, you could argue they may have copyrighted it. They copyright their brand and their name and their logo, but they would not really. So what they did was they kept it as a trade secret. And here it is 130 years later and as valuable as ever. So the rights in a trade secret are to essentially derive benefit from it and to safeguard against its misappropriation. So if someone breaks into the Coca-Cola company in order to steal the formula and then sort of goes out on a website and blogs about what they found, that's a misappropriation. Coca-Cola could take legal action to stop that in many ways. Likewise, if you find a file on the bus and the bus has a giant confidential sticker on it and says, if found, please return to this address, please do not open, and you open it and inside is the secret formula for Coca-Cola, and you go home and blog about it, that's a misappropriation. They could take legal action against you. So those are the rights that you would have to prevent an unauthorized disclosure of a trade secret. The duration of a trade secret, again, as long as you keep it a secret, it's going to last as long as it's valuable to you. So it can last indefinitely. Again, Coca-Cola is still going strong 130 years later. Now, a public disclosure will kill a trade secret, obviously. So you have to make sure you take steps to keep it a secret. But a confidential disclosure is okay. So under NDA or under CDA, you can discuss something that you would consider a trade secret, whether it be an algorithm or some know-how, and know that that should be protected and you'd be okay with doing that. Independent discovery and reverse engineering is allowed under a trade secret. So again, if you had the skills to take a Coca-Cola bottle, go home in the lab, and reverse engineer it back to its original chemical constituents and then figure out what the secret is, you have every right to then go to the market with your own version of cola, even using the same exact formula. And they would be powerless to stop you because you didn't violate any rules in reverse engineering it. You couldn't use their brand, you couldn't call it Coke, but you could certainly call it your name, Cola, and it could be exactly the same. So some examples of trade secrets, it could be like a formula, again, it could be a program, an algorithm, a database. If you have a really, really complicated database and you're not quite sure if it's going to be held protectable under any other IP, you can keep it secret. The process of how your business maybe does some chemical etching in a material can be protected under patent, but if you don't want that process being known or you want to use that process for more than 20 years, you would keep it as a trade secret. A supplier. So if you're in the business of creating sweaters and you get the best yarn from this random sort of supplier somewhere in Nova Scotia, that address of that supplier is a valuable piece of information for your business. It allows you to undercut your competitors and make profit. So that becomes a trade secret for you. Of course, to the supplier, their address is not a secret. They don't care. They're just in business selling yarn. But for you, subjectively, that's a trade secret, and you can keep it as such, hopefully making sure your competitors don't know about it. So in order to keep a trade secret, you have to obviously treat it as a secret. And what we mean by that is you have to take reasonable efforts to maintain its secrecy. So the misnomer here is that you have to sort of have your secret guarded by a room full of ninjas with sharks with laser beams on their heads and things like that. That's not true. The law doesn't say you have to take all technologically possible efforts to maintain secrecy. It just says reasonable efforts to maintain secrecy. And that's completely up to whatever the business is. So if you're just a mom and pop shop that makes really good fried chicken and you want to keep your recipe secret, maybe keeping that formula locked in the safe in the office is reasonable for that type of advice. So you don't have to get too elaborate. The duration of a trade secret, again, as long as it's valuable and it's kept secret, it's gonna stick around. Okay, so let's now that I've given you sort of the 4 different levers of IP, let's sort of start talking about how they start to converge, particularly for things like apps, software, algorithms, and things like that. So I've already talked about how software, the code that you would write, the source code, is covered by copyright. So that in and of itself is something that is valuable, can be licensed. If you're writing code, you have the right to disclose it to your licensing office. It most likely may not be, the most robust code, the most error-free code. It couldn't necessarily run an enterprise operation immediately, but there could be some kernel of the algorithm and implementation that provides a shortcut to someone else that would have to otherwise code up from zero. And that represents value. Because if you spent 6 months or a year or 2 years creating, a couple thousand lines of code, that code is a shortcut for someone else who wants to commercialize that idea, and therefore there's value. So it can be licensed, and you should disclose it to your licensing office. What it will not protect you, however, from is someone else taking a group of engineers and putting them in their own room and having them try and create similar code that does the same exact thing that your program does. Because that is not copyright infringement, because they're not actually copying your source code. In order for them to copy, they would have had to have looked at your source code and then go into that room and create something similar. Just like in grade school, if you can't look over the person's shoulder to see their test or their quiz, you're not copying. So no access means no copying. So you take a group of folks, put them in a room, and say, here's the spec, this is what I want the software to do, and I don't care how you do it, then their work, even if it's very close to your work, is not going to be copyright infringement. So how do you protect yourself against competition from doing that all the time? One of the ways you can do it is by trying to file a patent on your idea or on your software. Now, that's not going to be as easy as it sounds, because software on patents has a tough time working its way through the patent office these days, because software is always sort of living in that gray area between sort of the idea and its expression. And you have to make sure that you use a good attorney who's well versed in filing software patents, because they have to be able to articulate that this is a particular type of patent that is reducible to a machine or a device, and they have to use certain words that really the law is pushing folks now in order to have an algorithm cross the threshold into patentability. Because if you think about it, an algorithm, a series of steps, can be somewhat seen as an abstract concept or a mathematical concept, and if you write your patent as it's too mathematical or can be too broadly applied to other ideas, it's going to likely get rejected. But if you sort of apply it to a specific problem and show that it achieves a specific result that otherwise did not exist but for your algorithm, now you're crossing over the threshold into a more specific application, and that's what the Patent Office wants to reward. We want to reward these sort of ingenious solutions to problems that didn't exist previously. That's really what patents are trying to always do. So it's, yeah.
So is that to say that it might be better to patent something that sort of exists as almost like a flow chart as opposed to specific lines of code, that you're patenting the structure of the idea as opposed to the specific code?
Yeah.
Or not?
Oftentimes in a software patent, you're going to have your drawings are always going to be flow charts, because you're trying to show a process from sort of how it begins to how it ends. The specific steps you would take to build the system to code up are somewhat irrelevant for the patent, because you can sometimes two people given a flow chart can sort of code it up differently. And so you don't necessarily need to insert lines of code into a patent. It's rarely done. But what you would need to do is sort of show that your system is specific enough that it's not just doing sort of a general mathematical problem. If you're doing sort of general mathematical algorithms, those patents are going to get rejected all day, every day. Because the patent office doesn't want to grant patents on things that sort of wholly encompass the idea and sort of basically forbid anyone from sort of trading in that space in different applications. To them, those are too overly broad patents, and they don't want to sort of be in the business of telling people you can't do that technique on pen and paper because it's been patented by someone before.
Yeah.
So, but to answer your question, yes, when you have sort of the reduction to practice in a flowchart form, and as long as it's specific for a particular solution in a particular area, now you've probably crossed the threshold and you should think about talking to an attorney. So if you are lucky enough to get a patent granted on your algorithm, that's going to protect you from sort of the clean room coding efforts of the folks who want to sort of compete against you through their own software renditions. And that's valuable to have. There's controversy around those too, because a lot of people think that software patents are evil and we shouldn't promote software patents. But nonetheless, if done well and if done correctly, and if done, so you don't get these overly broad patents that think that they've, rediscovered something that people have been doing for 20 years, they can be a very effective means for furthering a business and trying to get an idea out into the public where it can actually be further polished and further refined, which is our goal in all this, at least my goal from my vantage point, is I'm not trying to create patents that are going to stop people from using things. I want to create a patent that's going to be a carrot for a company to come to me and license it so that they will bring these products forth to the market. So I'm interested in getting patents that are pragmatic and sort of provide a means to an end for a particular problem. I'm not interested in getting a patent that says, we did one-click shopping and now everyone that touches a mouse online is going to have to pay me a royalty like a troll. Now, trade secrets also play into this because, again, if you don't have the ability to get an algorithm and you're a little nervous about whether or not your competition will do clean room coding to sort of overpass you with deeper pockets, then trade secrets provide an ability for you to put a product into the marketplace that's functional, that works, and people can't sort of look under the hood and see what you're doing. So just another option to consider. And I think, yeah. So I think some of the things you should think about is particularly if you don't have a patent, you could still sort of have a very good position in the marketplace through branding of your trademark, which is a brand, and sort of your robust development of your app itself. So a nice example would be Facebook. Facebook did not have any patents when they launched and they got underway. Their social networking was a known thing in the world. They were not the first. There was MySpace, there was Friendster, nor would they have even filed patents when they were just sort of still operating sort of out of the dorm. So what they had was they spent all of their time making sure that their code was robust, worked, so it was spot on, and they had sort of their brand behind them. And so when it launched and started going viral and, you invited all your friends to join and they invited all their friends to join, it was that you were joining this company called Facebook, which had a product which was kind of cool and you can all share pictures of everybody and, your family halfway across the country could see your pictures and the pictures of the kids. So for them, they didn't need a patent. All they really relied on was the strength of their app, the strength of their software, and their branding. And so I think that's something that you need to think about if you're going to be sort of creating future companies or future ideas for companies. Is if you have the ability to work with your office for a patent, great, you should definitely do so. But just because your area might be an app that is well trodden and you don't think there is any patentability there, should not just mean that you give up. There's still the ability for you to do well in the marketplace through effective branding and through other types of protection. So don't rule out open source or trade secrets per se, particularly if you're a business. The university would not necessarily be interested in protecting a trade secret, but as a startup company you might be. And open source is always in a way of raising exposure to your product and getting sort of a customer base to sort of get familiarized with your product, like that FFTW program I mentioned. It can sort of, or think of Red Hat, which produced the operating system and let it out for free, but then has a business of selling services around it. So open source open sourcing your sort of software or your application, and then sort of once your customers are hooked, being able to provide them either improvements or services around that is another way of sort of sinking hooks into a marketplace. And then again, trade secrets will protect you in the event that one of these other levers is not fully coming through. I think that is my last slide.